Very good. I see Mr. Asfar and Ms. Berger in the courtroom. Welcome. And we are ready. Mr. Asfar, if you're ready to proceed.
Thank you, Your Honor. May it please the court. I'm Rick Asfar of Cottony Construction Law, here with my trial attorney, Mr. Mason, appearing on behalf of plaintiff, appellant, Mr. Gary Santoro. May I reserve 5 minutes for rebuttal?
Yes, I'll let you know when you get there, Mr. Asfar.
Thank you, Your Honor. Mr. Santoro's car dealer, the appellee surety's bond principal, misrepresented to our client that the car it was selling to him had a catalytic converter and that it could be warranted. Mr. Santoro relied on those misrepresentations, bought the vehicle, and unfortunately was only able to drive it for a total of about 550 miles over a period of about 3 or 4 months before it became functionally inoperable. And the warranty company said, we're not honoring this warranty because this is not a warrantable car, contrary to what your dealer said. Mr. Santoro made all of this clear to the surety months before the surety was served with process by providing a detailed 19-page complaint, bill of sale, air pollution control documents, and the warranty that was no good.
Mr. Asfar, is there any authority, contrary to the cases that were argued in the briefs, that distinguish the recoverability of fees when suit has been filed but service of process has not been made, versus what the cases talk about, which is negotiations and bringing or notifying the insurance company of a claim before suit is actually filed?
I'd like to focus the court's attention on the Johnson on this point. And if I can direct the court's attention specifically to page 1019 of that opinion, what it actually talks about, Your Honor, is the initiation of action. And I appreciate that a lot of the cases do talk about the filing of the suit, but I think that those cases are materially distinguishable because those are first-party property cases where you have post-loss conditions that an insured has to comply with. In this case, our surety bond obligee is not in contractual privity with the surety. The dealer.
Interestingly, the surety doesn't have any pre-suit notice requirements, and the statute on attorney's fees doesn't have any pre-suit notice requirements. However, the case law does seem to impose that requirement despite the language of both the contract and the statute. And I don't think that the Johnson case or any of the cases, to the extent they apply to insurers generally, they don't seem to create a distinction that you're trying to make here, which is it's okay that we filed suit first because we never served them until later.
I appreciate the court's observation. I appreciate the court's point. I sincerely appreciate the court understanding where I was going to go, that it's not in the statute, it's not in the bond. This is something that is an outgrowth of the cases. But I do want to emphasize.
Even in the Johnson case, counsel, it talks about there has to be an incorrect denial of benefits. Did we have an incorrect denial of benefits in this case?
I believe we
just
did.
Have a lawsuit that was filed and then a year later there was service?
I believe there was an incorrect denial of benefits in that there was just
was there ever a demand made for benefits before this surety was sued?
The demand was made on the surety prior to service of process.
But not pre-suit.
No, but there's a very good reason for that. And this is one of the nuances that I think are unique to the surety context and why I think that there is a need for some clarification here. All of the cases that we're looking at are first-party property cases. And what we have here is a surety case. And the reason that this is significant is because if you look no further than the motions filed by the surety and the answers and affirmative defenses, what they say is, we are not primarily responsible. You have to go and get a judgment against this dealer before anything. And I'd like to direct the court's attention to affirmative defense number 2, which specifically says and I might be jumbling a little bit here, but the gist of affirmative defense number 2 is any liability we have, and elsewhere they say, which we deny we have any liability, is secondary to the dealership's liability. And then when they file their motions for protective order, they guard against the motion for protective order by saying, hey, we've never made a coverage determination. So you don't get our files, you don't get how we evaluate this. And you know, you are not going to get that until you get a judgment against this dealer. So that's why this is such a critical case, I think, to clarify this area of the law, because I agree with the court. I agree with the direction y'all are going in. You guys are 100% correct. The cases that we see are all talking about file suit, with the exception that Johnson says initiate action, which is a little bit of a distinction. But setting that distinction aside, I think, and I would suggest that action hasn't been initiated until there's service of process and the parties kind of go up. But setting that point aside, this is the case where the surety dug in and specifically said, hey, you can't come against us until you sue the dealer and you get a determination against them, and they can't pay.
When did you
primarily liable.
When did you give American Safety the first opportunity to settle this? When?
I think the first opportunity to settle this would have been when the notice was provided, Your Honor, and we said, here is our claim.
Did you make a demand?
I beg your pardon, Your Honor?
Did you make a monetary demand in your notice?
A monetary demand was not made in the notice, and I would suggest that there was a reason for that.
So when was the first monetary demand to American Safety?
I believe the summary judgment had the detailed breakdown of the numbers. Although not addressed in the answer brief, I believe that the numbers at that time were provided in our answer to the interrogatories that were served on June 1st of 2016. Okay. So the surety did have numbers.
My question is, you know what a demand is? You do insurance work. You've done first party, I'm sure, third party.
Typically on the appellate stage, usually not at the trial court level, but yes, Your Honor.
Okay, but it's routine practice to make a demand, a money demand. You have two defendants. You decided not to serve one, you pursued the other, but yet there's two pockets here. And when did you make the demand on American Safety whereby they could evaluate that and make a determination? And then based on their determination, you would decide whether that was unreasonably denied, which would trigger the statute or not.
I appreciate the court's question, and I am going to answer it, but I do want to have an opportunity to highlight what I think is a very important consideration. The first time that there were numbers that came out of Mr. Santoro was in his June 1, 2016 interrogatory responses, which was approximately 10 months after he provided notice of the lawsuit. Then there was the motion for summary judgment, and this is just going on the record. I don't know what kind of informal conversations there were between counsel. That is not something that's in the record, so I won't get into it. But I can tell the court that there was a discovery response. I believe it is at record pages 385 through 88, where there are numbers that are provided to the surety shortly after it is served with process. And then there is the motion for summary judgment, which is filed after the summary judgment is entered on liability against the dealership. And that, I believe, was in 2018. But I do want to take a moment to highlight for the court why I think that the numerical demand would have been premature. And it's something that is kind of comes up tangentially comes up in one of the opinions that I've cited in our briefs, which is the Allen versus State Farm case. But the thing that's really significant is that in every single one of the cases that the surety is relying on, there is a coverage admission first and then numbers second. And that's really important because you have to remember that what these statutes are about is protecting consumers. And there's at least a contemplation that a consumer will be able to bring a claim by itself. An unsophisticated consumer without lawyer help would be able to bring a claim on a dealership bond itself, where the dealer goes down. And that is made clear by the fact that it's a one-page bond that says very, very little. I mean, this is the type of thing that's out there to protect consumers. And if there isn't
the thing is, though, your client is protected by the bond. So what we're really talking about, and they received a settlement based on the bond. So now we're talking about the next step, which is whether or not there are attorney's fees that are owed by the surety. And you know, we know what the statute says. We know how the bond deals with bonding the auto dealer. However, the case law is across the board consistent that fees would be limited to the work associated with filing the suit after there has been a failure to negotiate in good faith, basically. And then the confession of judgment cases also talk about confessions of judgments apply when there has been a breakdown in communications leading to the filing of a lawsuit, and then there is a settlement, and then the confession of judgment kicks in. So trying to square that all together is what we're stuck with here, because the statute dealing with attorney's fees talks about a judgment actually being entered. So it doesn't contemplate on its terms a confession of judgment. Again, case law has developed that. But confessions of judgment don't apply unless there has been a breakdown in negotiations before suit is filed, leading to the filing of a lawsuit. And here, lawsuit was filed before there were efforts to negotiate.
I appreciate that chronologically, the facts are what they are. And I'm not here to dispute what the facts are. I would respectfully.
Then we also see from that it wasn't until April of 2019 that the final numbers were finally presented to American Safety. So this is 4 years has gone by. And we as a court, as well as the body of case law, are looking to determine why does this simple case of such a minor amount take this long? Is it because somebody's trying to set up a fee award, or who exactly is dragging their feet? Who's causing this problem? Because clearly there's a problem here.
I appreciate that, Your Honor. And respectfully, in this case, I like Ms. Berger personally, and she was not the person who handled this at the trial court level, but I think that I would have to lay this one at the feet of the bond company, because the bond company did not take a look at the materials and say, you know what, there's coverage here.
Yeah, but
They had what they
this case is really not that unique. It's no different than suing somebody that has State Farm coverage. I mean, State Farm's not, primarily liable, but they're the insurer. You make a demand. You make a demand on the insurance carrier. That's where the money is. You didn't make a demand. Now, I understand, because we're going to talk to Ms. Berger about stringing this case along and having an aggressive defense and denying liability and things like that. That seems to go in your favor. But the point we're making, and Judge Silverman made very clear to you, is you didn't make a specific demand that was denied. And then you had to litigate in order to force them to pay. Now, we all know a settlement can be a confession of judgment if you can lay it in the record that you sued because they unreasonably denied your demand.
Your Honor, we had to sue in order to get number one, in order to get liability against the dealer, which the surety was saying was a precondition to them entertaining.
But you don't have to buy that argument, and I know you don't. You can file a demand right off the bat. I mean, you're going to buy that language? I mean, come on.
But Your Honor, if I don't know what aspect of my claim is covered, how am I going to say what my damages are? If the warranty piece of it isn't covered, that's going to affect what my damages demand is going to be. If they say this part is covered and this part is not, and if you look at their motion to dismiss, they throw stones and say there's certain claims here that you can't take against us, and their second motion to dismiss against us. But if we don't know specifically what they think is covered and what isn't, how can we make a monetary demand, especially if you are a consumer who's unsophisticated and might not know what it's going to take to repair the car? These folks never came and took a look at the car, Your Honor. In 5 years, they never came to take a look at the car. Instead, they said, we got your notice.
Mr. Asfar, the bond amount is $25,000, right?
Yes, Your Honor.
Okay, was there anything precluding your client from making a demand for $25,000? Or they may have rejected that and said, well, we need to figure out what is really covered and what isn't, which is the negotiation language that the cases talk about. So what precluded your client from making a demand for $25,000 or something less than that if it felt that was the value of his claim?
I think that the attorney's ethical obligation to not demand something that it doesn't believe it's entitled to. If we don't know what's covered, and if we don't know what's covered, if we don't know what the value of the claim is, because we don't know what components they're saying is or isn't covered, then if my trial attorney says, hey, give me 25 grand, I think he's got a concern that he's perhaps being a little overly aggressive and perhaps not ethically doing what he's supposed to do, which is making a good faith demand based on the facts and evidence before him. And if we don't know what coverage is, we can't make that demand if we don't know what's covered.
Plaintiff's counsel is able to ignore what the case law says in terms of negotiation by saying, we really don't know how much you're on the hook for. We just know you have to cover this.
I think what the trial attorney said was, we have a claim, can you tell us whether or not it's covered? And I would direct the court's attention to his October 2016 letter where he lays the whole thing out and he says, listen, tell me if it's covered. Tell me if part of it's covered. If you can just tell me what kind of coverage I've got here, I can give you a number based on that and we can move on down the road. But in this case, what the surety did was and I want to direct the court's attention to Ms. Cole's affidavit at, I think it's R 684 to 688. They retained the defense firm not to investigate, but to defend the claim.
Mr.
This is not
Asfar,
good faith.
isn't the insurance company, for purposes of what the case law says, and in terms of negotiating in good faith, isn't the insurance company also entitled to know, what are you claiming? You know, I'm having some difficulty with the argument that we need a coverage determination, but we really don't know what we're claiming yet.
Your Honor, if this was a typical first-party insurance carrier, 626.9541, they would have had 30 days to make a determination, and they would have been required, if they need something to make a coverage determination, they would have been required to tell us what they needed and why they needed it. And we cite that in our reply brief, and that didn't happen here. Frankly, Your Honor, I think this is more than just unreasonably withholding payment. I think this is bad faith, that they say they hire a law firm not to investigate, but to defend. And that is the words of Ms. Cole in her affidavit in opposition to
they hired a law firm to defend because you sued them and your client sued them and served them with process. So of course they have to defend. But let me just let you know, we've asked you a number of questions. I've let you go a little bit long. You're at your 5 minutes if you want to reserve those for rebuttal. Or you can go forward if the judges have no questions, your choice.
I appreciate that. If Your Honors have any further questions, thank you, Your Honors. I have a feeling I'll have a lot to say in my rebuttal, so I will stand silent for now.
Plan it out, Mr. Asfar, because you'll have 5 minutes for your rebuttal.
It's always a challenge. I'll do my best. Thank you, Your Honor.
Thank you. Ms. Berger.
Thank you, Your Honors. May it please the court, Erin Berger from Giassi Law on behalf of American Safety. As Your Honors have pointed out and hit on, the key inquiries in this case are summarized with the following questions. Did Mr. Santoro provide notice of the claim to American Safety before filing the lawsuit? Did American Safety deny the claim prior to Mr. Santoro initiating the lawsuit or even before he served American Safety with the complaint? And did any action that American Safety took force Mr. Santoro to initiate the lawsuit? And was there a bona fide dispute between Mr. Santoro and American Safety prior to the initiation of this lawsuit? Because Mr. Santoro cannot answer these questions in the affirmative, the confession of judgment doctrine does not apply, and the trial court correctly denied his request for fees. As Your Honors pointed out, this is not a case where judgment has been entered under 627-428, so they're not entitled to the mandatory fees for that reason. Mr. Santoro advanced the argument that the post-suit payment constituted a confession of judgment, and in that period, based on that payment post-suit, he was entitled to fees. In order to demonstrate his entitlement to fees under the confession of judgment doctrine, however, Mr. Santoro had to demonstrate the following: that there was a payment of a previously denied claim following the initiation of an action and prior to the issuance of final judgment. It's obviously undisputed that American Safety made a payment after the appellant initiated the lawsuit, but under the facts of this case, there's no way for American Safety to have made anything other than a post-suit payment. The authorities applying the confession of judgment doctrine, as Judge Silberman pointed out, are consistent across the board and have required a party seeking fees to demonstrate that the insurer incorrectly denied benefits or took some other action that forced or compelled the insured to file the lawsuit in order to be entitled to fees under the doctrine. Appellant did not and cannot demonstrate that there was a previous denial of a claim or that he was forced to file suit by any action taken by American Safety. The appellant offers several arguments in effort to misdirect the court's attention from these plain and simple issues. Again, he maintains that the award of fees in this case is mandatory. The cases cited by appellant in support of this argument are not confession of judgment cases, with the exception of one, and that one was Ivy versus Allstate, and there pre-suit notice was given, and the incorrect partial payment was determined to be an incorrect denial of benefits. There's no judgment that's been entered, and the confession of judgment doctrine, the Bryant versus Giovera case and the basic export cases that were cited by American Safety stand for the proposition that not all post-suit payments by an insurer will constitute a confession of judgment for which an award of fees will be warranted. The confession of judgment doctrine authority cited in my briefs demonstrate that fees are available under the doctrine when there has been a pre-suit denial, a dispute over a partial payment, or inaction by an insurer that forced the insured to file suit. As your honors pointed out, there is no case that suggests that attorney's fees are warranted where suit is initially filed and service awaited for some arbitrary amount of time, and then payment made after service is made. And I think it's important to point out here that even if there were a proper, or if there were an authority to support the position that appellant sets forth, that it's okay for them to file suit and await service, here we have the fact that within a month of receiving that notice, American Safety provided notice to the appellant that they were investigating the claim. Rather than respond to that notice to provide any additional documentation, the appellant just served the complaint because he didn't receive payment. And the only explanation that was provided by trial counsel was, well, we didn't receive payment, so we served the complaint. The next argument that the appellant makes to misdirect this court's attention from the basic issues are that the relevant consideration for this court is whether he provided notice of the claim prior to the service of the complaint. Again, he cites no authority in support of this contention. And as I said, he made no response to the August 2015 letter from American Safety's counsel.
Ms. Berger, one thing that's interesting about the sequence of events here is ultimately there is a denial in the answer to the complaint. For whatever reason, it was denied. And the statute dealing with attorney's fees talks about a reasonable sum as they typically do. So in this situation, could the trial court have said, look, you should have given notice before filing suit. However, this is a surety case. It's not a first party insured case. Let's go forward, hear what your attorney's fees are. And then the court potentially could reduce the fee award to compensate the plaintiff for reasonable litigation that occurred after the denial in the answer. Why would that not be a valid approach?
It might be a valid approach, but it wasn't the approach taken by the appellant. Again, the only argument that was set forth was that he was entitled to a mandatory award of fees because we paid post-suit. And I would argue that the denials that are claimed to have been made are in a motion to dismiss and the answer in affirmative defenses. The denials in the motion to dismiss, Your Honor, aren't denials. What they were was the bond's attempt to sort of, I guess, I just lost my words, to narrow the issues that were being presented here. In the complaint, there's multiple issues that were raised that aren't covered by the bond, particularly issues under Chapter 634, I believe, and the FDUPTA statute. Those are not recoverable under the bond. So, I mean, when we're brought into suit, we're entitled to challenge the issues that are being presented, and that's not a denial of liability. That's a legal argument in terms of what's being presented in the case. And with regard to the...
Remind me, in terms of the sequence of events, when the auto dealer was out of the picture in this case, how soon after that was an offer made by your client?
Your Honor, I believe it was about 6 months. Their attorney withdrew effective Halloween of 2018. And by April was when the offer was made.
And there had been a judgment, a default at that point entered against the dealer?
Yeah, I would argue it was essentially a default summary judgment because they were no longer defending, Your Honor. And it's important to note too that in that motion for summary judgment, again, we have no claim for damages. There's nothing in there that says this is what they owed us, this is what we seek from them. The order doesn't say anything about damages. It just says they're liable and they're going to be responsible for attorney's fees. And if I could just go back to one point in the sequence of events, Your Honor, with regard to the answer being a denial, that argument is belied by the fact that 6 months later, in October of 2016, trial counsel finally responds to our request for information and says, and recognizes that there's been no coverage determination made, So the argument that he considered the claim denied by our motion to dismiss or our answer and affirmative defenses, Your Honor, is just belied by the timeline of events here.
But your third and the fourth affirmative defense clearly denies liability.
Again, I would argue that under the FIGA versus.
Either it has legal effect or it doesn't. You denied liability.
Again, under the FIGA versus Rubin case that was cited in our answer brief, Your Honor, I would say, you know, in this context, we were forced to file a suit. If we defend our rights under the case while we're still trying to get information here, then we're not denying liability. I'm sorry.
How was your client forced to do anything?
I think she
Well, because they brought
misspoke.
us
You
into
said
the-
you were forced to file suit.
I'm sorry. We're forced to
You're
defend the
the
action.
suit.
Well, I
Yeah.
don't know that you were forced to defend or not. How were you forced to defend? I mean, you have a finite amount of money,
Correct.
25,000. And it wasn't until the eve or the day of summary judgment that you filed your proposal for settlement.
Correct. And I believe
And it was
that the memo-
litigated for 3 years.
It was litigated for that long. Again, the dealership was involved in that litigation for 4 years. Our liability being secondary to his and protecting our rights under an indemnification agreement where he's disputing the claim, Your Honor, we have to do what we need to do to defend our interests and do what we need to do reasonably to try to get the information from Mr. Asfar's client. The timeline of events here suggests that we did do those things. American Safety sent multiple correspondence to trial counsel. When we received no additional information, we served formal discovery, and he recognizes that in his answer brief that the documents weren't presented until they responded to the request for production. There's no record evidence what was provided then, and I think the record demonstrates that even after that, there were questions concerning what was due and owing. In his response to the request or the interrogatories, he does list some amounts, but I'll point out that he says, I was charged $5,411.30 for an extended warranty. I made a $7,000 cash down payment. He's claiming that he's owed the diminished value of the vehicle, but also the amounts to repair the catalytic converter. I mean, it's just sort of vague and unclear, and we've sent correspondence after that demonstrating we need some more information here. And I'll point out too, that when he filed his motion for summary judgment, the amount that he was claiming for that extended warranty was only $700. So even at the time, he was misrepresenting his damages. And the other thing I'd like to point out too, is that counsel argues that in the answer brief, or I'm sorry, the reply brief, that American Safety had all the information it needed to make a coverage determination and a payment when it received the notice in July of 2015. The only thing that was provided was a written letter saying, we're suing you, pay us. And then a copy of the complaint and the 3 documents attached to the complaint, which were an unsigned bill of sale, the air pollution control statement, which in itself says it doesn't serve as a basis for a lawsuit, and then a nondescript document that appeared to be an application for a service contract. And I don't know how American Safety was supposed to discern what was demanded at that time, but that's why we requested additional information. By this time, Mr. Santoro had served discovery on the dealership, and we noted in our record that we tried to get information from the dealership as well. So we did what we needed to do in terms of our investigation, and Mr. Asfar's client was evasive and vague and didn't respond to our request for information until we had to seek judicial intervention and serve formal discovery. Our actions in the litigation have been described as aggressive. I think that is an unfair characterization. Again, we only filed formal discovery because we received no response from Mr. Santoro or his trial counsel to our request for information informally. We were forced to file 2 motions to compel. And even after that, it was just sort of unclear. We participated in mediation. We didn't file a motion for summary judgment. We were trying to work with him this entire time, and obviously being mindful of the fact that the dealership was still involved in litigation as well. When that became clear that he was no longer going to be defending the lawsuit, and when Mr. Santoro received a judgment against the dealership on the basis that were claimed, we did what we needed to do to adjust the claim based on the information that was ultimately and only for the first time filed in the April 2019 motion for summary judgment.
Ms. Berger, something that I don't believe was addressed in the briefs. When does the cause of action accrue against the surety? Do you know offhand? If not, I mean, it's not.
I don't know that there's clear case law on that issue, Your Honor. It's our contention that the cause of action accrues when liability is demonstrated and conclusively established against the dealership.
Because the way the bond is written, it is essentially failure of the dealership to perform its obligations. And that's not the exact wording, but that's the context of it. And so in my mind, the question is, well, is there a failure to perform their obligations when there's a demand and a failure to pay or to settle, or does it actually have to go to judgment against the dealership before a cause of action arises against the surety?
Well, when the dealership is defending the cause of action and claiming that they didn't do anything wrong, I think there is an issue of whether or not the cause of action accrues against the surety unless and until he admits it, or until a court has entered a judgment.
And the reason I ask that question is it sort of plays into the appellant's approach, which is, look, is this bond still in place or not? Because the bond has language where it can be revoked. So is there coverage? It does make sense to me that that question is asked. Is there coverage under the bond? Without saying, look, we know the amount that we're claiming. They may not know it because the dealership may still step up and pay. So it's an interesting area of the law with relatively little guidance.
Sure, and I don't disagree with Mr. Aspar that there's certainly some nuance here and some differences in how the cases maybe would apply to sureties in the third party context versus first party. But I mean, they invoke the insurance code and they invoke the insurance cases to say, because sureties are treated as insurers under Florida law. And I would just point out to you, even if that's a question that could be applied in some cases, I don't think it's relevant here, Your Honor, just because the August 2015 letter that we sent clearly acknowledges that we issued a bond, that Sanka Cars is our principal under the bond, that we're investigating this claim and we want some more information. Again, that request for information went unanswered. Rather than cooperate with our attempt to investigate, you know, there's crickets and we get served with a complaint. A couple other issues, Your Honors, excuse me. The appellant raises in their initial brief the issues of compliance with or public policy. We made the argument in the answer brief that these were not preserved issues, but even if they were, the policy here does not support an award of fees. The policy here supports the court's determination that fees were not warranted because under 627-428, the purpose is to discourage insurance companies from contesting valid claims and to reimburse an insured for their attorney's fees incurred when they must enforce in court their contracts. Again, we've discussed there was no denial here. There was no pre-suit denial for sure. The appellant was not forced to file suit and American Safety's action did not compel him to file suit. The record demonstrates that Mr. Santoro's notice of intent to investigate the claim, or he received notice of our intent to investigate the claim and didn't even really respond to that request until more than a year later. The fact that he was invasive and not forthcoming suggests what we argued in the Goldman case and other cases cited in our brief, that this was nothing more than a race to the courthouse in an attempt to create a claim for fees. And the fact that there was, you know, very little cooperation from Mr. Santoro after we requested information and tried to investigate further supports that argument, Your Honor. And the fact that no real demand was made until April of 2019, and we quickly paid that, also evidences the lack of cooperation here and the fact that the trial court was correct in denying the motion. There's no basis for fees under 320.27. That's been established by Florida law under Hubble and Snow. The modest sum of the bond was not intended to cover attorney's fees. And for these reasons, Your Honor, unless you have any additional questions, I'll stand on my brief and request that the court affirm the trial court's order denying the motion for entitlement.
Thank you. Mr. Aspar?
If I might have just one moment, Your Honor.
Yes.
Thank you, Your Honors. Thank you, Your Honors. I want to start by just responding to a question that Judge Silberman had asked, and that was when does the liability of the bond company accrue? Old Republic versus Reichman, it is cited in, I believe, my initial and perhaps in my reply. The bond company's liability, the bond company is liable at the time of the Principal's Bad Act. So the Principal's Bad Act in this case was October of 2013. The case wasn't resolved as to the dealer. The dealer's liability wasn't determined until January of 2019. There would have been a statute of limitations problem if we didn't sue them from the outset. So I just want to flag that issue for the court, and I think it's a very important one. There were a couple of other things that Ms. Berger discussed. I would, rather than get into them in detail, I think a lot of it is addressed in my reply brief. I would respectfully request that the court kind of reevaluate my reply brief in light of some of the arguments that have been made today. With respect to sureties, I have an opposing counsel who recently referred to them as an insurance company that never pays, because what they do is they're supposed to lean on the dealer to do the work. And what they're really supposed to do is investigate the claim dispassionately. They're not supposed to just be a shill for their principal and go along with whatever the principal says. They're, especially in this consumer context, they're supposed to step in, take a look and say, hey, what's right and what's wrong? And what they needed to do was say whether or not there was coverage. Instead, what they did was they withheld coverage, and that was a tactic, that was a negotiation tactic to try to get my client to take less than what it was entitled to. And it's a threshold determination.
Your client didn't know what he was entitled to at the time there were any pre-service negotiations or discussions, right?
The numbers were not discussed pre-service. That is correct, Your Honor.
So
but if they would have sent,
what is the surety supposed to do when it
they're
has
supposed
no
to send
numbers?
somebody to take a look at the
Hang on,
loss.
Mr. Asfar.
Sorry.
You said that they wanted to pay less than they were obligated to pay. How did they know what amount your client wanted them to pay?
In every single insurance case cited by the defense, the insurance company promptly sends somebody to take a look at the loss. That didn't happen here. They take a look at the loss. They say, okay, I see you are missing a catalytic converter. That's worth $5,000, but it may or may not be within coverage. I see you've got this problem and that problem. They didn't do that here. And that's typically what happens in these cases is the carrier will send somebody out to take a look at the loss. They refuse to do that. So, I mean, and that's something that they're required to do. I do want to point out that there are some dealership cases, A.N. Sanchez, which is one that's cited in my papers. There's no case that says that in a dealership context, you have to provide pre-suit notice. The law is silent on that in the dealership context in either direction. It's just not stated. And I would respectfully submit that under the unique circumstances of a surety case, it just doesn't make sense to give pre-suit notice to the surety before you name them as a defendant. Because what we would do is then we would sue the dealer. The dealer would would push us around. We would then make a claim. We would then go back and forth with the surety. The surety might drag it out. They might drag their feet. In this case, they never told us what their coverage determination was. They withheld that until the very end. And, you know, they asserted and they incorporated into their own defense all of the defenses of their principal. So they rode along with what their principal was doing. And they did describe the principal's defense as aggressive. Ms. Berger did that when she was arguing the fee motion. She wasn't a trial attorney, but she did argue the fee motion at the very end. And even she termed the defense by the dealer as aggressive. If the surety would have stepped up, investigated, and taken care of the consumer, because that's where their duty is. Their duty is to the consumer, and that's the Shannon Gin case. I think that we would have seen things develop in a much different direction because my client just wants a car and they want to move on. They don't want to be 5 years out without a car. That's such a critical asset, especially in a state like Florida. It's critical that you have a car so you can go to work and all of those other things. And instead, there was an action that required lawsuit to address, and that is the coverage determination. We had to get that coverage determination. They said that the dealer was primarily responsible. The dealer dug in. They never asked, as far as we can tell, they never asked the dealer. Maybe they did, but they decided that they were going to ride along with the dealer. And that's where they should have looked. They should have looked at the dealer in the investigation because the dealer had all of the documents. There is contractual privity. There was reference to a right to indemnify against the dealer. So whatever the surety pays, they can go back to their principal to get that covered. And so this is a situation where really it is the surety was driving the bus. They could have said there was coverage and they could have cut this off at the pass. And then they could have gone back to their dealer principal and they could have recouped the benefit from the dealer principal or the insiders, because that's typically where the indemnification obligations go.
Mr. Asfar, that takes us to the end of the time. Take 10 seconds to conclude.
Thank you, Your Honor. In light of the foregoing, in light of the policy, we respectfully request reversal because this was an incorrect denial. We do feel that at a minimum, there should have just been entitlement, and then we could have talked about the amount of fees or the limited amount of fees. At that point, it would be consistent with public policy. And for the foregoing reasons, we respectfully request reversal, and we thank the court for its time.
Very good, Mr. Estar, Ms. Berger, thank you very much. That concludes the oral argument session